rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1, CACR 170543, State of Arizona versus Hope Lynette King. Counsel, I'd remind you that we're recording this oral argument, so please identify yourselves and who you represent at the beginning of your remarks. Each of you will have 20 minutes to present your arguments. Appellant's counsel, if you'll watch the clock and retain as much time as you'd like at your own discretion. And also, keep in mind we've read the briefs, have looked at pertinent portions of the record, and have discussed the case this morning in conference. With that, counsel for appellant, you may proceed. Petitioner, yeah. So.
May it please the Court, I'm Assistant Attorney General Andrew Riley, and I'm appearing on behalf of the state in this matter. The PCR court here committed a clear abuse of discretion when it contravened Arizona Supreme Court precedent and overturned King's convictions and sentences that have been affirmed by this court and final for more than a decade. In State v. Bilkey, the Supreme Court held that a condition that is diagnosed after a conviction that may constitute newly discovered evidence under Rule 32 if the condition existed at the time of trial but was not diagnosed because the condition was not medically recognized at the time of trial. In State v. Amaral, the Supreme Court then held that the research and advancements that occur post-trial don't constitute newly discovered evidence itself, nor can it make a previously recognized condition newly discovered evidence under the Rule 32. The PCR court then clearly erred when it found that when it held that this postpartum psychosis condition could constitute newly discovered evidence because it's undisputed, and it's never been disputed, that postpartum psychosis was a recognized and diagnosable condition at the time of trial. That is something that all the experts agreed on. That's something that the literature agrees on. And there's been nothing pointed to the contrary that it wasn't a recognized and diagnosable condition at the time.
So that, counsel, that's your view, then it's game over. That's it.
Yes, Your Honor.
Let's talk about the condition, because postpartum psychosis has been around, according to Dr. Barnes, it's been around since 400 BC, when Hippocrates talked about the condition that he had noticed in women there. So, I mean, obviously, this has been known for many times. But is the state's position that there are times, or at a single time, when that becomes set in stone, the condition becomes set in stone, if you will, so that it can't change? So as of 2002, it was frozen in time, essentially, that it can't change because it all falls under the same umbrella.
The moment it's a generally recognized condition, then it doesn't change. We're going to continue to have advancements, but to answer Your Honor's question specifically with that, it's the concept was on. There was a point in time when there was a concept that was understood that women in a postpartum situation experienced these things. When we get to a point where there's a recognized diagnosis that's generally recognized in the mental health community, that is generally recognized medically, then that's where we get. That's the end point. We're not talking about postpartum psychosis was also initially referred to in I believe the 18th century or 19th century as pluriporal mania and there have been all sorts of other concepts that have been used to describe something that has been seen. But the condition itself, postpartum psychosis, with its set criteria and its structure, symptomology or what have you, has been recognized and diagnosable for decades. It's not the suggestion that the pluriporal mania or anything along those lines, or what Hippocrates noticed, is somehow a recognized condition, and there you go. But when it becomes medically recognized, and again, that's something that's not disputed in the DSM-4 TR. You have the condition, it's recognized, you have the criteria, you go through and you diagnose people according to that. In fact, Dr. Hibbert did that in this very case when she diagnosed King in 2011 as having this. She used the DSM-4 TR with the as a recognized condition in the DSM-4 TR. Dr. Barnes testified that she routinely used that to diagnose people. Again, Dr. Barnes has been practicing, she's by her own account, since 1995, specializing in postpartum mood disorders, including postpartum psychosis, and she had been diagnosing people since then. So this isn't, at the very least, in this case, that concept was ingrained, was recognized, and was diagnosable at the time of Ms. King's trial in 2002, and there's no dispute to the contrary on that.
Let me read you from Dr. Barnes' testimony, where the question was asked, what is the defendant's diagnosis, or what was Ms. King's diagnosis? He said it was bipolar 1 disorder with peripartum onset with psychotic features and also post-traumatic stress disorder, dissociative subtype. The question I have for you is that the condition we're talking about?
The condition is the condition we're talking about is postpartum psychosis. To make an analogy,
But aren't there many facets?
Certainly, there are many facets of a heart attack. I mean, you have a myocardial infarction. You can call it an acute coronary syndrome, and there's different types of myocardial infarctions. But at the end of the day, there are nuances. Certainly, there's no debate that there are nuances. But it's a heart attack. At the end of the day,
well, we could call all of this mental illness or mental disorder. We could call the whole thing.
But there's there's particular symptomology for a specific diagnosis, and even if we break it into that subset or however, all those things were recognized and diagnosable at the time. All those things were available under the DSM-4 TR. All those things were expressly related and discussed in the DSM-4. There's nothing new in that in the diagnosis as said now, or as said then, as now.
Counsel,
yes, Your Honor.
The trial court said in its decision that all three expert witnesses agreed that the defendant could have been diagnosed with postpartum psychosis, but then the court proceeds to say, but the question is how reasonable it would have been to make that diagnosis. What was there in the record that showed that all three witnesses, expert witnesses, said that there was some place, there were physicians, whether they were in Rochester or Miami or Palo Alto, but she could have been diagnosed, just not in Arizona?
I dispute that. I mean, again, the diagnostic criteria, the symptomology, and the diagnostic criteria is in the DSM-4 TR. So, I mean, if mental health professionals use that, identify the criteria and diagnose things accordingly. That hasn't changed. So, to say that forensic psychiatrists or forensic psychiatrists or clinical psychologists or whatever specialty you would prefer to make this diagnosis, to say that clinical psychologists specializing in postpartum mood disorders in California were somehow able to do it, but not those in Arizona, seems a little unrealistic.
Right, and I'm not asking you your opinion. I'm asking you in the record. The judge found that. The judge said that all three experts said this defendant could have been diagnosed with this disorder. Is that in the record anywhere?
That all three experts testified that she could have been diagnosed with this disorder. To my knowledge, to my recollection, I don't believe that there was a specific person in Arizona that was cited that you could have gone to this person in Arizona to make that diagnosis.
So was it a matter of geography then for the court, that they were saying it's less reasonable the further away you get from Phoenix, Arizona?
Well, the diligence aspect, saying that it wasn't reasonable, misses the point entirely. Again, under Bilkey, to to constitute newly discovered evidence, the condition has to exist at the time of trial and not be diagnosable. It has not, the diligence under Rule 32(1)(e), you have whether it's a newly discovered material fact, and two is the diligence, the defendant exercised diligence in finding it and bringing it to this court's attention. The newly discovered fact, which is the newly discovered material facts, were discovered after trial. That doesn't happen under Bilkey unless the condition was not medically recognized. You don't even
But
get
they
to the
could
subject.
find an expert, counsel. How do you
Well, no,
explain that?
they did find an expert. In fact, Bruce Peterson, well-respected, seasoned, very good defense attorney, consulted with two mental health experts on this very issue. And after consulting with the mental health experts, determined in his notes, in the notes provided from the file, show that there's a discussion about postpartum depression, there's a discussion about postpartum psychosis, and there's a doesn't equal insanity in that, after the consultation with that mental health expert. What this boils down to is we don't have newly discovered evidence. What we have is we now have a new attorney more than a decade after, or nearly a decade after the conviction, with a new expert that comes with a new opinion. It's not, a new opinion does not equal newly discovered facts under Bilkey or under Amaral, because the condition existed at the time of trial, could have been diagnosed, and in fact could have been presented. Bruce Peterson pursued the defense, but ultimately decided not to present it because, in his opinion, it was going to fail as a defense. And it didn't rise to the level of insanity after consulting with his experts. And following that strategic decision, he decided to present it at mitigation, and that ultimately succeeded in the sense that she received the most mitigated sentence allowable under the law. To make this, again, the diagnosis itself is the opinion. It's a new opinion. The condition is what needs to be discovered after trial. In Bilkey, PTSD didn't exist. It was impossible to get the diagnosis because it did not exist. So no matter how hard you tried to do it, you wouldn't be able to accomplish it. Postpartum psychosis is different in the sense that it was a recognized and diagnosable condition, and if something's recognized and diagnosable, it's just as a matter of common sense, you could get it if you actively pursued it. Now, if there's a distinction to be made on what type of specialist you would have preferred to have made that diagnosis, well, again, that goes to the specialist. I'm not going to go to a general practitioner to review a brain scan, but that doesn't mean I couldn't. It was impossible for me to get someone to review a brain scan when the brain scan was available and the technology was available to review it. All we have here is a new opinion.
So boil this down to a sentence or two. First of all, are you saying that court erred as a matter of law, or because of Amaral, or are you saying that the court misapplied the factors?
I'm saying the court erred as a matter of law under Bilkey. I mean, the rule from Bilkey, as it's been cited by this court in a number of unpublished opinions, the rule from Bilkey simply is that a diagnosis of a post-conviction diagnosis, there's a lot of words there, a post-conviction diagnosis of a condition can constitute newly discovered evidence if the condition existed at the time of trial and was not medically recognized. That's one-on-one in Bilkey. That's what Bilkey says. Amaral then goes on to say that advancements in the understanding of the condition aren't newly discovered evidence, nor do they make a previously recognized condition newly discovered, because to allow so would be a never-ending circular loop. It's an end run around finality. It eviscerates finality, and it's an end run around Strickland at that point.
Counsel, so in Amaral, the court says that, and they're talking about Bilkey, what made Bilkey different was that the condition was, quote, not yet recognized, and thus could not have been diagnosed, and then they use the word impossible. It would have been impossible for the trial judge to, and then found the condition. So my question to you is that a complete bar? Let's say somebody, let's go back to my geographic point. Does that mean that it would have been impossible to find someone in Arizona to make that diagnosis, or beyond?
I don't think a geographical limitation on that would be necessary. would prevent it in any way. I mean, we have experts all around the world. If it's a recognized condition and there might not be an expert, that particular expert in Arizona, then that wouldn't necessarily make it impossible or make it so you could not obtain the diagnosis. We deal with experts all the time across state lines.
Who was out there that could have given the diagnosis? The new evidence here is Dr. Barnes' testimony, correct? That's the new evidence being offered.
Again,
it's her opinion. Who could have given that to him in 2002?
Well, Dr. Barnes herself could have. She testified that she was an expert, and she's been an expert in this, practicing in it since 1995. It's out.
She conceded that in the record.
That she could have. She
could have given the exact same.
Well, no. Yes.
Exact same opinion.
Yes. That she could have diagnosed her with postpartum psychosis, with the bipolar disorder, with the postpartum onset, with the PTSD, with the depersonalization, derealization. Those are all symptoms that were present and available and diagnosable in 2002, and she had the ability to do so. She had the expertise to do so. She'd been practicing. She testified that she'd been practicing at that point for 7 years. She was, again, this was not a new concept. She was the head of an international organization.
Did you raise that in your opening brief?
Yes.
That point.
Yes.
That exact point.
That she could have diagnosed. That she could have all these concepts were there and diagnosable, and she acknowledged as much that they were there and diagnosable with the DSM-4TR.
And so when the court, going back to the decision, says all three experts agreed that the defendant could have been diagnosed, was the sort of what's the name of the Barnes expert? Was that what her saying? I could have diagnosed her, and then what about the other two?
The other two said that she could have been properly diagnosed. Again, the criteria was there, then the condition existed, and she could have been diagnosed. In fact, I believe I was faulted in the response for suggesting somehow that they were required to get Dr. Barnes. There was never a suggestion from the state. Certainly Dr. Barnes wasn't the only one who could have been able to do this, because again, it was a recognized and diagnosable condition. Everybody concedes that fact. It's undisputed that she could have been properly diagnosed. That's why it boils down to this is simply a new opinion from a new attorney with a new expert, and that's not newly discovered evidence. And even if diligence were a requirement, to find it as a newly discovered fact, the diligence simply wasn't. The diligence was there in the sense that he pursued experts, consulted with them, and ultimately decided that it wasn't a viable, and it didn't rise to the level of a viable insanity defense. And to Ms. King's diligence, which would actually be the second prong or the second element under Rule 32(1)(e), that you have to diligently pursue and secure this evidence and then bring it to the court's attention. Ms. King talked at her sentencing that she was aware personally that she suffered, in her opinion, a very serious postpartum mood disorder. So to the extent that she disagreed with her counsel's...
Is that the term she used, a very serious
postpartum
mood disorder?
Yes.
Not postpartum depression?
Not postpartum. To my knowledge, very serious postpartum mood disorder.
And and to you, is that the same as being aware that she suffered from postpartum psychosis?
Yes. Well, no. I mean, in the sense that it puts her on notice that she could obtain a diagnosis or could seek out another expert if she, under those circumstances, if she wants to. But whether it's postpartum depression or postpartum psychosis, postpartum depression can devolve into psychosis. But without getting into the weeds of that, it's just the underlying that she's on notice that she thinks she suffers from something, and then she sits on that and waits a decade to get a new attorney and a new expert to reach that diagnosis and then bring it to the court's attention. That's the actual diligence element, and that wasn't addressed. That wasn't even addressed in the court's opinion below, which automatically is an abuse of discretion by not addressing that.
Let me understand. So the diligence does not go to finding somebody to make the diagnosis back in 2002. It goes to whether it was...
Yes.
It's the 10 years after.
For this case, yes. Again, just looking at Rule 32(1)(e), you have newly discovered material fact that is discovered after trial. Under the rule, the condition needs to be discovered after trial, i.e. recognized after trial. And then you need to diligently get that diagnosis and bring it to this court's attention. For, as an analogy's sake, PTSD, Bilkey. Let's say I'm convicted in 1970 and I try to bring a Bilkie claim. Well, I can't bring it now. PTSD was recognized 30 some odd years ago. I still need to diligently seek out the diagnosis and bring it to the court's attention.
Were the dissociative episodes, which are said to have prevented the discovery of her psychosis, one of the items that Dr. Barnes said she could have diagnosed in Ms. King? Was that part of the litany? You mentioned a number of aspects of her mental illness that could have been diagnosed in 2002 and weren't. Was this piece of the dissociative episodes also part of that?
It was
or is
part
that the new part.
That depersonalization and derealization, the dissociative symptoms that she diagnosed. And first of all, important to note that she's the only one out of the 5 or 6 people that have treated her to ever reached that diagnosis. And
But then that's a matter of credibility for the Superior Court.
True, but those were all diagnosable at the time of Ms. King's trial. Those were all recognized conditions.
The dissociative episodes as well,
The dissociative symptoms, yes.
as it relates to postpartum psychosis.
Yes. And if I could save my 20 seconds, I will.
Danny, we'll go ahead and add.
Sorry.
Can you add 2 minutes to both sides? And you can have. We'll give you a couple
Oh,
minutes
sure.
to
Appreciate it.
about it. So, I've asked a lot of questions.
Good morning. My name is Joseph Roth. I represent Hope King, and may it please the court. Now, this case involves complex issues, as we've talked about, but I wanted to, before I got started with some of the prepared issues and issues that were raised in the briefing, I'd really like to address, unless the court has specific questions right away, at least 2 points that were just discussed in the last argument. Number one, the question as to whether all 3 experts could have, that the testimony or the finding was that all 3 said that Hope King could have been diagnosed at the time of trial. That is a massive oversimplification of what the testimony was. Dr. Barnes testified and agreed that she thinks she would have been able to give a diagnosis of postpartum psychosis, but then went on to say that because of the substantial developments that she testified about for a day and a half, she does not believe it's reasonably likely that a medical professional could have, or that it's reasonably likely that Hope could have received the correct diagnosis. Now,
But
that
was there
was the
testimony that all 3 of the experts said she could have, and I understand we're not talking about where, how far you'd have to look for that, but was that the testimony from the experts that, yes, she could have been diagnosed, all 3 agreed?
No, that's not a correct interpretation of the record. I think the key part of Judge Gordon's opinion there is that the question is not could Dr. Barnes have diagnosed, but the reasonableness question, which I know you're not asking about there. What Dr. Pitt said is that he could have reached his diagnosis that he opined about and believed that was the correct diagnosis, and that the component parts that we're talking about could have been discerned by polarity, that someone might experience dissociative symptoms. Those are not unheard of component pieces. Dr. Hibbert said that she believed Dr. Barnes would have been able to, that someone with Dr. Barnes' knowledge. Dr. Barnes said, I believe I could have, but she was at the edge of her field. She was, a very tip-top of being expertise in that area.
So, for clarification, she said that she could have given the same diagnosis that she did under oath.
No, in fact, she could not have, in part because what she said her diagnosis was, I would have diagnosed Hope King with postpartum psychosis. And then she went on to say, but using the categories of the DSM, here is under DSM-5 how I would categorize it. Some of that diagnosis, including peripartum onset, did not exist in the DSM-4. So no, I don't think she would say I could give that exact diagnosis. What I believe she was opining about was saying, I agree I could have diagnosed Hope King with postpartum psychosis because of her understanding of where the science was at the time, at the edge that in her clinical experience, she was sort of maybe the only person or extremely rare person that could have, whereas someone with general expertise, a forensic psychiatrist, not unlike the state's expert, she opined would not have been able to do that, and I believe Dr. Hibbert similarly opined.
What about the third expert that apparently, at least according to the opinion, also said the defendant here could have been diagnosed with the condition at the time of trial?
Yes, Your Honor. I believe that the testimony was that, and I would have to check this, but I believe the testimony was that Dr. Barnes could have, or someone like Dr. Barnes could have, not that it would be reasonably possible to expect Hope
But
King
who
to have
was that
received it.
expert? What was the
That was
name?
Dr. Hibbert.
Hibbert.
Hibbert. So Hibbert was just pointing to Barnes.
I believe so. I believe so.
Where in the record, counsel, is that testimony specifically? If you can give me the.
I don't have a citation. I believe that Dr. Hibbert testified on.
No, I'm talking about Dr. Barnes.
Oh, Dr.
Where
Barnes.
she qualified her ability to give that diagnosis.
Yes, I believe that would have been in the transcript for the 28th, and I don't have a line set for you, unfortunately. It's possible it's in the afternoon of the 27th, but I believe it was on the 28th. Although I'm happy to find out and point the court in that direction. So I wanted to address that point because there was not a direct testimony that, yes, I believe, all three said, yes, she could have got this. It was much narrower than that, and Dr. Barnes went on to testify extensively about why it was should not be reasonably, through reasonable diligence, she would not have been able to receive that diagnosis, in part because the component pieces that Dr. Pitt was talking about, as the judge found, based on a lot of testimony and evidence, the current understanding at the time did not appreciate the significance of the interplay between those symptoms. The constellation of symptoms that Hope was experiencing were not recognized, widely recognized, or understood to be indicators of an atypical psychotic presentation of symptoms.
I have a question for you. So
Yes,
if
Judge.
Dr. Barnes would have been that rare expert who could diagnose her appropriately, why was she not within the reach of the defendant back then?
Well, with respect to that question, Your Honor, Mr. Peterson testified that he sought out expertise in mental health. He knew something was wrong. Everyone who has seen this case knows something is wrong. The judge said, even if the mental health experts don't tell us, we know something is wrong. He sought out expertise, and he got to someone not unlike Dr. Pitt, a forensic psychiatrist who generally testifies in criminal cases and has expertise, and those people aren't the type that Dr. Barnes is. Whether he was where was
in 2000?
Dr. Barnes was 5 years or six, 7 years into her practice in California. She was working in academia. Whether her name, there's no evidence indicating that anyone ever knew to even suggest her or that this type of issue required some kind of particular expertise.
Didn't you just say that one of the other experts, Dr. Heber, said that she could have diagnosed Ms. King?
Well, that Dr. Barnes could have, or
That Dr. Barnes could have diagnosed Ms. King because she was the leading expert in the field at the time.
Well, Dr. Hibbert knows about that because Dr. Hibbert herself is an expert in reproductive mental health. It was a burgeoning field that was very tiny. The one reason no one in Arizona could was because it was essentially non-existent in Arizona. The testimony was that I think around the time Dr. Hibbert entered the field in the mid-2000s, I believe, no one else was really practicing this at all as a specialty or focusing on it in terms of their clinical practice.
But isn't it then fair to ask about where, because it really boils down to where the defense was guiding their search and where were they going to get the leading person who could give the latest, right? I mean, we have a serious case. You would expect that diligent counsel would go to, at least, I mean, California is not too far.
Well, 2 points to that. The evidence, I don't think it has to do with geography, only in that the lack of someone in the local community is significant. But the evidence was that Mr. Peterson sought out expertise to inquire whether there might be some defense or mitigation about a serious mental health disorder, that he knew something was wrong. And who do I seek out? Forensic psychiatrists. They frequently testify in these sorts of cases. Testimony was presented on that question. The state had a full opportunity to present whatever evidence about how easy it would have been to discover other experts in the field who existed, what advertisements there are, any other evidence there might have been could have been presented and wasn't. And the court's role here is not to relitigate the case for the state as to what questions might be asked, but to look at the evidence and see whether there's a basis for the judge's opinion, and there clearly is in this case. One, that Mr. Peterson exercised diligence, and two, that there's substantial evidence indicating that it's not reasonably likely to expect that someone would make that diagnosis.
Counsel, let me ask you. So, as I understand your argument, in recent years there's been this substantial development in the constellation of symptoms. Is that right?
That's correct.
Can you point me to a single decision anywhere in the United States that recognized that recent advances in postpartum psychosis warrant a new trial. So someone has posed your exact argument, and a court, like us today, said, you know what, you're right, this has advanced enough on this continuum that we now are going to award a new trial. Can you point to a single decision in the United States?
Your Honor, about postpartum psychosis, no, I don't believe I can, although I'm certainly happy to look further. What I can point to are plenty of cases where, and I believe I cited them in, I think it's footnote 3, there are cases where changes in how we determine scientific facts affects whether there's a new trial. DNA, we've known the existence of DNA for a long time. The condition of DNA existing is known. The ability to identify it, to pull it from different sources, to test it reliably, changes over time. And based on the evidence that can be shown, if evidence demonstrates that through reasonable diligence that DNA could not have been tested in the past and now can and would affect the verdict, that would constitute new evidence. That's why we have an evidentiary hearing over these issues. That's why the standard is one that is necessarily case by case. Postpartum psychosis is an exceedingly rare disease. And more than that, it's also very rare that women who suffer from it hurt their children, although it's an alarming rate, something like 4 to 6%, I believe, was what was the testimony in the record, that about 1 out of 1,000 mothers suffer from postpartum psychosis, and something around 4 to 6% of those women either kill themselves or attempt to kill themselves or hurt their children or attempt to kill or hurt their children.
Well,
so we're talking about a very, very small universe of possible cases to match your question.
But I guess I haven't looked at it, but I would assume if you have a mother who has committed an act of violence against a child within a short period of time after birth, that it's quite often that the postpartum either psychosis or depression defense is raised. Yes, Your Honor, certainly. There are cases where women have been found guilty except insane. There are cases where women's sentences are massively changed due to this circumstance, and I believe there are some in Arizona. What's unique here and makes it unlikely that there's going to be a case like this one is, on top of the recent developments in the case making the body of case law smaller, the exceedingly rare occurrence of her disorder, she also received an astoundingly long sentence due to the functioning of our mandatory minimum and consecutive sentencing laws. So she is in a very narrow circumstance where all of these other safety valves that might have brought the case to the fore or caused a different result, she's not in those places, and she's in a unique position here where she's presenting substantial evidence from experts in the field to say, to explain why, in this case, she could not receive the diagnosis reasonably in 2002, 2001, and can now, and it constitutes new evidence entitling her to relief. I wanted to address, before I turn, one other topic that came up that was discussed, that my friend from the state discussed, was Bilkey establishing some kind of bright line rule. That issue was litigated by the state in this case. The Court of Appeals already rejected that argument directly as to whether there's some bright line outcome out of Bilkey. Bilkey, as the Court of Appeals already found in the previous opinion, is an application of the general rule and did not change the general rule. But isn't Bilkey the question, and in the earlier appeal in this case, wasn't the question there whether there was a colorable claim that would necessitate an evidentiary hearing rather than a new trial?
Sure, but the purpose there is to say, sort of like a summary judgment motion in civil practice. If I take the evidence here and I believe it, and there's not I weigh it, is this a claim that would prove and provide relief, or should we dismiss it now? And the court said, taking the evidence that's been presented, based on the standard to be applied, which Bilkey said, which this court said didn't change after Bilkey, it's an application of it. Yes, there's a colorable claim. The purpose of the evidentiary hearing is to test whether it's more than colorable, but it doesn't change what standard applies. The same rule applies.
Well, Amaral has different paragraphs. One, it says these are the elements for a colorable claim, and then it says, Okay, but your position is that they're identical. Colorable claim. Why can't you just get a new trial then?
My position. Well, you have to have an you have to have an evidentiary hearing to allow an adversarial process to test whether the evidence that, when believed, constitutes a colorable claim actually bears fruit, actually proves out that there's not some kind of impeachment evidence or something that undermines it massively. That's why we had the evidentiary hearing here. I understand your point about the different pieces of the analyses, pre-colorable claim and after. The one that's relevant here is the same. Is it new evidence, which means was this evidence discoverable through reasonable diligence or not? If not, would it probably have affected the verdict? Those questions are the same in Amaral and Bilkey, which deals with, is it even rise to colorable, or when you have the evidentiary hearing to decide, just like after a motion for summary judgment that's denied, okay, we've said you can prove these claims, now you have to do it.
Let me ask you a question. So I was going through the record and I see this handwritten letter from the defendant in September of 2002, in which she effectively says, I have postpartum depression, and says, to quote, I know I was extremely mentally not stable due to a serious disorder that is truly just now, 2002, becoming shined upon with a whole new light. Does that have any relevance to the new evidence question?
I believe it has relevance in that she knew something serious was wrong with her. She had evaluations. Dr. Rosengard diagnosed with her a litany of the component parts and didn't know what to do with them and said, I recommend a multidisciplinary approach. That piece of evidence, I suppose, would go to whether she diligently pursued her post-conviction claim. 2 points on that. I suppose that evidence is relevant. Does it make it probative or not? Perhaps. I don't think it's dispositive at all that she recognized something was seriously wrong with me after I had my baby, as she explained to mental health evaluators. But number one, the state did not raise this issue. You will not find in the proposed findings of fact and conclusions of law any argument or assertion that Hope King failed to prove that she was diligent in pursuing her claim. Number two, the state says that was not alleged and nothing was offered on it. The Hope King's petition for post-conviction relief and the amended petition at page 29 has a section that starts with, starts with King diligently sought legal representation and expert opinion as soon as she discovered the new standards being applied in postpartum mental health evaluations. We had an evidentiary hearing at which the state was free to offer witnesses and testimony and evidence on any element that it claimed was not proven based on the allegations and evidence offered in the petition. The state didn't do that. I think this claim is waived, frankly, and I also think that the fact that there's no evidence indicating that she didn't act diligently also bears eliminating that argument from the state's brief.
But as I understand the state's argument, they're saying that to the extent this was a condition that was recognized, that is a bar to what the relief that your client is seeking. Is that accurate?
I believe that it accurately states what the state's position is. I think that is an emphatically incorrect statement of the law. Bilkey and Amaral do not establish a bright-line rule that says if a condition is generally known, like the concept of PTSD, also known as war fatigue or shell shock, if that's generally known, advances in the science, increased understandings can't constitute newly discovered evidence. That is not what Bilkey says. It's not what Amaral says. In Amaral, what happened there, the court said, the petitioner asked the PCR court, please consider new science that helps us understand why juveniles are impulsive, why juveniles exhibit poor judgment. We have new science that has been in the Supreme Court that says why that's so, that the brain develops at a slower pace than we've previously understood, that the executive functioning part of the brain is actually not developed till much later, so we can explain why that's so. The court didn't say, no, what the court said was, the fact that this person was a juvenile and that juveniles exhibit immaturity, impulsivity, poor judgment was generally known at the time, number one. And number two, was expressly considered by the trial court in that case, the sentencing court. The sentencing court received evidence and testimony from experts, a clinical psychologist, and other witnesses about that particular defendant's unique impulsivity, his age, the fact that there was testimony that Mr. Amaral in that case, although he was 18, I think 18 at the time of the offense, was more like a 13 or 14-year-old at the time of the offense. The court considered his age, said the only mitigation I see is possibly your age, and sentenced him. It was on that basis that the Amaral court said there is not Rule 32 new evidence here. It's not new because the behavioral characteristics of being a juvenile are generally known, and it was considered here, thus it probably would not have affected the verdict. In other words, Amaral applies the general rule, the one we asked be applied here, and that the court did apply here. Amaral does not say juveniles are generally known, and thus any increases in understanding can't categorically constitute newly discovered evidence. That's not a correct statement of what Amaral says or of the law. Our case is not like Amaral. The analogy would be if there's evidence that said, you didn't know, Judge, that he was a juvenile. We have now determined a way to figure out that he's actually 13. Everyone thought he was 18, he's really 13, and we want you to, we've discovered a new method of determining age, and it turns out he's a juvenile, and that comes with these characteristics that you need to consider. Here, the concept of postpartum psychosis was generally known, as was discussed back to 400 BC, that mania, infanticide is in the Bible, I believe. That concept was known, but as the judge said, the interplay of the disease, the interplay of her diagnosis, the interplay of symptoms that presented as an atypical psychosis was not known.
Why isn't Dr. Barnes's testimony that she could have diagnosed her with postpartum psychosis the end of the story under Amaral, which says we're talking about conditions that it would have been impossible to have assessed?
Your Honor, I believe that's a reference back to Bilkey, where it was describing PTSD didn't yet exist in the nomenclature. He had been suffering from it, and then he could be diagnosed. So it would have been impossible to have that particular diagnosis at the time. What Bilkey says is the standard is, it asserts the standard for what new evidence is, and then says that is easily met here because it would have been impossible. It didn't say the only way to meet that standard is if it would have been impossible. Amaral also doesn't say that. And that simply, that is not the law or the governing legal standard. That's why there's an evidentiary hearing to decide whether the evidence through reasonable diligence could have been discovered, not whether it existed somewhere on earth through extreme diligence. Go ahead, Your Honor.
What kind of factors do you propose would go into that reasonable diligence assessment?
Well, I think it would necessarily vary case by case. In a case like this, we had to rely on the expertise and judgment of experts in the field who would talk about how patients were observed, how they were diagnosed, what types of behaviors and symptoms are relevant, and how what's the scientific understanding for the significance of those symptoms and what they mean. For example, here, Dr. Barnes testified about around the time of trial, the concept of psychotic episodes was generally viewed in terms of delusions, hallucinations, which that is a type of psychosis. It was not as well understood that the atypical presentation that many women who suffer from postpartum psychosis exhibit doesn't look like that. Well, one very important symptom is what they call waxing and waning, meaning that the symptoms fluctuate. You can be in a moment of lucidity followed by decompensating out of reality. That requires a set of testimony and expertise that is unique to this type of case. Another type of case might be where it turns out a bottle cap that no one noticed before that's in the corner of a crime scene photograph had DNA on it, and there would be a whole different set of evidence to establish whether or not it would have been reasonable to examine that bottle cap for DNA or not. So I think the test serves two purposes. It is limiting. It serves a very important limiting function so that very few things qualify as newly discovered evidence that can entitle someone to relief. The state's brief talks about the interests of finality, but that's built into the rule, and it's necessarily case by case, and that's why the evidentiary hearing is so important. And the standard of review at this court is for clear error, and I think the court should easily affirm.
Okay, thank you, counsel.
Thank you.
Mr. Riley.
Thank you, Your Honors.
To begin, just to respond to, again, the substantial developments in which we're talking about do not apply. They do not, the substantial developments themselves cannot constitute newly discovered evidence and cannot turn a previously recognized condition into a new condition. We talk about how terminology has changed between postpartum.
Counsel, what if you couldn't have been diagnosed? Let's say that the symptom presentation had evolved enough that on X day there wouldn't have been a diagnosis, but on Y, I understand that it was a condition, it was out there, it was recognized, but X it wouldn't have, Y it would have.
But that's a bait and switch at that point, because they've talked about the category changes. The PTSD underwent a category change from the DSM-4 TR to the DSM-5. It was originally listed as an anxiety disorder, and now it's a trauma and stress-related disorder. That doesn't mean it's new now, just because there's been certain category changes, and that's exactly what's being talked about here, is the terminology has changed a little bit. So since the terminology has changed, and without question, we know more about postpartum psychosis now. I have no doubt about that. We know more about PTSD now. But that's not the question. Does it constitute newly discovered evidence under Rule 32.1e? And to say that that the nomenclature changed and the terminology changed, so now it's a new thing, well, the terminology is always going to change. The nomenclature is always going to change, and we're always going to get a better understanding. When the DSM-6 comes out, there's going to be a nomenclature change. There's going to be a terminology change.
What about ways to diagnose? What if those change? I mean, just like in the DNA context, I mean, that gave a whole new world of ascertaining, you know, who a potential criminal was.
And if there were a blood test that you could take right now and say that you have postpartum psychosis, then certainly
an enhanced MRI or whatever it might be, then that would be that
possible.
Possible,
but it doesn't change the fact that it was a recognized condition. You could have gotten to it. You sought it out. You decided that it wasn't going to rue the day, in your opinion, and so you said no. And then a decade later, you get a new attorney and a new opinion, not new fact. It's a new opinion. The fact is the condition. The opinion is the diagnosis.
So, counsel, you're saying that if we were to come out with a blood test today that would show unequivocally whether or not a patient has postpartum psychosis, that is not available to.
I would back off that. I would back off that in the sense that mental health, DNA, and fingerprint analysis, those are objective, solely, purely objective, evidentiary kind of things. Mental health is not that way when we're dealing with it with the DSM and we're dealing with the symptomology, and because of that, there is an appropriate limitation, and the limitation is appropriate as listed by Amaral, with that the advancements don't make it, and there is a bright line rule. If it was recognized and diagnosable, that's the end of the discussion. And for that reason, the PCR court erred as a matter of law, and we would ask that this court grant review and reverse.
Okay.
Thank you.
Thank you both for your fine arguments this morning. The court will take this matter under advisement and issue a decision in due course. We're now adjourned.